Hi, thank you for joining our webinar. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the incredible Daniel Weidner and Taylor Hayes, two of Nebraska's construction lien law gurus. Today's webinar topic is Key Considerations for Lien and Global Releases. So without further ado, I would like to introduce you to the fabulous Daniel Weidner and Taylor Hayes.
Good afternoon. I'm Dan Weidner. I'm a shareholder at Cooley Justice and the chair of our construction practice. And I'm sitting here with my colleague and trusted associate, Taylor Hayes, who is fresh off of a week-long jury trial and delivering a $1 million verdict for one of our best clients. And we're here today to talk to you about the importance of releases as they relate to the construction industry, with a specific emphasis on lien releases, lien waivers, and global releases of claims. Today, if you've got any questions, feel free to go to the webinar chat box on the right, plug them in, and we'll answer the questions at the end. So without further ado, Taylor and I are going to start talking to you about releases. We want to start by talking about them at a really high level, and then we'll get into the nitty-gritty on the individual constituent components of each type of release. So first and foremost, it's important to understand what releases are. And what they are is that they're a document that discharges certain rights. In other words, they let go of a right, they agree to not enforce a right, or it limits your available remedies. And so with that understanding, it's really important, in our opinion, to understand that as a general rule, when drafting a release, the more detail, the better. It's better to have the terms that you've agreed upon memorialized in writing, so that once you get a document signed, you have a firm understanding that it's resolving matters in the format that you wish to resolve them. And so really, we need to take the time to say what we mean and include all important provisions within that lien release or global release. Taylor and I both have multiple clients that will, come to us when they're on the verge of resolving a dispute potentially, and they'll ask us, do you just have a simple one-pager that we can use? And we can absolutely put together a simple one-pager, but what we find is that the cost savings of that simple one-pager can be detrimental down the road, because that simple one-pager may not address all outstanding issues. And so we want to talk to you about that, because it's really important that you understand what's being released and the legal impact of that before signing it. And at times, you're going to benefit greatly from having built that out in further detail. The last thing that is really important to understand with regards to the kind of big picture of releases is the release should essentially build a timeline for when things are going to occur, if it's anything more than simply releasing a construction lien, so that everybody can understand when people's obligations should be satisfied, and when you're either going to get paid or when you're going to be obligated to record the lien release.
And with that general overview, I'll give a little bit of a preview here to what exactly we're going to cover. So there are numerous different types of releases that you may be familiar with. We're going to focus today on 3 different types: lien waivers, lien releases, and global releases or settlement releases. And while there's very important distinctions between all of these, you'll notice as we talk about each individual type that the general themes that Dan just went through with you kind of pervade all of them and are important for all of these. So the first type of release that we're going to talk about today is a lien waiver. Now, many of you, having been a part of the construction industry, are probably quite familiar with what a lien waiver is. It's generally a release of a future right to record a lien. That's something it's very important to understand, that is the basis for a lien waiver, and also to understand that simply because you're familiar with a lien waiver in one state, say Nebraska, that doesn't mean that the details of what's allowed and not allowed is going to be the same if you cross over into Iowa or South Dakota or Kansas or any other state. Lien waivers are very influenced by state law, so it's important to understand exactly what you're signing and where you're signing it in so that you know what law is applicable. Now, these are often very simple documents that you're going to be signing in connection with receiving a payment. So because of the nature of that exchange, you might be inclined to simply scribble down your name, check the number maybe matches the check that you're receiving, and go on your way. And while that might work for you sometimes, it's very important to read the waiver before you sign and ask questions about anything that doesn't look right before you sign the waiver. Because again, based on what the state law is here, particularly Nebraska, you want to understand exactly the rights that you're waiving and what you're giving up. And our final point on lien waivers today is to be aware that you don't want to preemptively give up your right to record a lien at all. Lien waivers typically may reduce the amount of a lien that you can record, but you don't want to preemptively say, I'm not going to be recording a lien, and put that in writing and sign. With that high level overview, we'll go into our next category of releases, which is a lien release, not a lien waiver. The key distinction between these two is that while a lien waiver was providing a release of future lien rights, a lien release is going to cancel a lien that has already been filed. Releases should be signed after the amount has been paid in full and received. And while that may sound like a very common sense piece of advice, we have seen instances where this has gone sideways, and you don't want to be in a position where you've recorded a lien, you've been paid on the lien, or excuse me, you believe you've been paid on the lien, you release the lien, and then your bank tells you a week or two later that the check that you've received didn't clear. So you want to make sure that you're going to give time for the payment method to clear your bank before you actually execute and record the lien release. Additionally, consistent with Dan's initial overview, we want to be very specific about the job and the amount that you were paid and that you are releasing from the lien. It's very important to get these details right so that you don't run across a bad actor who takes a more open-ended release and tries to construe it in a way to take more than you had intended. And our final piece of advice on lien releases is, in our experience, the Register of Deeds offices in the various counties across the state of Nebraska can be very particular about different details when a document is recorded. So it's very important that you understand the details of the release, the formatting details, the signatures are legible, the sizing is correct, because if you record it with the Register of Deeds and something isn't quite right, they're likely going to reject that and say you need to refile it. So this isn't something that you simply want to hit the file on, not look at any of those emails and just assume that it was accepted. You can run into problems if you think you've recorded a release and you haven't. So be aware of those details and make sure that the release has actually been recorded and accepted.
And before we move into global releases, I'll give you one real-time example. We recently had a lien release that we were recording rejected by a Register of Deeds, where while the signature block identified that our client was the president of the company, the notary block didn't also identify our client as the president of the company. It just said that Joe Blow appeared before this notary, and so the release was rejected and was not enforceable to release the lien. And that's something that it was the first time that's ever happened to us. We hadn't seen it before, but when a Register of Deeds has the ability to accept or reject something, you do want to make sure that you're complying and that you are allowing yourself time to respond to any issues such as that. Now, as we transition from lien releases into global releases, what's important to understand with global releases is oftentimes when you have to record a construction lien, it's because something didn't go perfect on a construction project. There are times where it's simply a matter of a payment dispute that's related to the owner not having the funds, a construction loan not being fully funded, or just a general contractor not passing the funds on fast enough. But there are other times where the need to record a lien is a result of the project being delayed, a defect in the construction, permitting issues that the owner is feeling that it needs to be compensated for. And when you're a subcontractor on a project, those issues may or may not impact or may not be impacted by your performance. You may have been a cause of a delay. Perhaps you had nothing to do with the delay and the delay was some other subcontractor's fault, but that may be what is slowing down your payment. And so when that happens, especially if a lawsuit becomes necessary, what you're usually doing is you're resolving the entirety of the dispute related to the project and not just the payment obligations. And so with that in mind, you have to understand that the document is going to be much more comprehensive than a document that simply releases a lien that's been recorded against property. Accordingly, the details are vitally important because the global release is a very broad document that's used to resolve the dispute. And so regardless of how much you need to be paid on the project, you don't want to rush into signing these because they may give up rights that are much broader than just releasing the lien that you recorded against the property. And at that point in time, you should stop and consider whether you need an attorney involved. The reason we suggest this is not just because, attorneys, or clients involving us in these disputes is how we keep food on the table at home and our lights on. But it's because there are times where nefarious players will try to sneak things into releases, give up additional rights, or require you to take less money than maybe you're entitled to, but still provide full warranty on the project or indemnification and defense obligations, which could be the subject matter of an entire webinar. And so you need to make sure that you fully understand what it is that you're getting in exchange for releasing the lien and what you're giving up as part of the document. And consistent with my commentary earlier about the document needing to essentially create a timeline, what's really important is to have the document baked out so that you know that you're going to get paid within 3 business days of full execution of the agreement. And then consistent with what Taylor was saying earlier is then you want to allow yourself time for that payment, if it's not in certified funds, to clear your bank account. So then you want to say that I've got 2 weeks from the date that you receive payment until you have to have the lien release on file, or have the agreement drafted that you're not required to release the lien until you've received notification that the payment cleared your bank account. And then if there are other obligations, such as you need to make payments to second-tier subcontractors or suppliers, that you give yourself the time to do that and then collect lien releases from them. And so at the point in time where you're signing a comprehensive global release, there will essentially be a roadmap from start to finish of payment and then obligations to release claims. So what you also need to understand is that you want to read and reread the scope of the release and the payment terms to make sure that what you're doing is you're resolving the specific disputes that you intend to resolve. Oftentimes, subcontractors may have multiple projects for the same general contractor, or a general contractor could have multiple projects for the same owner. You need to understand that whether the context of that document is addressing all of the claims that you have between the parties, or only limiting them to one project or a subset of that project. You also want to have an understanding of, if somebody doesn't perform their obligations under the agreement, what protections do you have? What remedies do you have? And for example, that's why you want to have that timeline of, I'm not required to record a lien release until I've been paid in full. This is especially important if, as part of the settlement agreement, you are agreeing to accept less than 100 cents on the dollar. If your agreement is not drafted appropriately, you can limit your remedies where you agree to take 70 cents on the dollar and then you don't get paid. And now, instead of having a right to go after them and try to collect 100 cents on the dollar, you may be limited to suing for a breach of the settlement agreement, having to incur additional non-recoverable attorney's fees to enforce the agreement. And you've just given the other side a free 30% discount. So at that juncture, it's really vitally important to understand the document that's presented to you and what it means before you sign it. Now, that transitions into the next point. Is within the document, there's going to be the release, and that's the provision that gives up certain rights and claims. And with regards to settlement and release agreements, there are two general categories of releases. There's a general release and a specific release. And understanding the difference between the two is absolutely vital to understanding the rights that you are giving up. So first, a general release is a release of all claims that you have against the other party or all claims that they have against you. And so that can, as drafted, is much broader than simply the project that you are working on. That can be a dispute over money that you lent them. That could even be a dispute related to an intentional tort where somebody may have assaulted somebody or there was a car wreck, but it is any type of claim that could end up in court is being released as part of that general release. Now, contrary to that is the specific release, and the specific release is only releasing a specifically identified subset of claims. And so what you will often see is that when you're reading that release language, that is, Taylor hereby releases Dan of all claims, causes of actions, debts, promissory notes, etc., that when you have a specific release, it will then say arising out of or related to, and then it will insert some category. For construction projects, you may see an explanation of the agreement that you have with the owner. It may specifically define the individual project or even specifically define a portion of the scope of work, such as the siding repair work performed on XYZ building. Those releases can be effective to reduce claims related to one dispute, but may leave you open to liability or exposure for other disputes. And so it's important to be intentional in understanding, are we releasing claims related only to what we're getting paid for, or are we trying to resolve any and all disputes between the parties? One of the reasons that this is so vital is that you can, in a settlement release agreement, you can release future claims. And so from an owner's perspective, that may release unknown and concealed construction defects. That may put you in a position where you no longer have warranty rights, or you no longer have the ability to go after a contractor if the roof collapses 2 years after it was installed through no fault of you or a natural disaster. So because of that, you want to work with your counsel to truly understand what you are giving up and ensure that whatever you are giving up, you are receiving adequate consideration in exchange for the release that you're providing. So with that, we'll pause and see if anyone has any questions or would like further explanation on any of the topics that Taylor and I covered today.
First of all, thank you so much, Dan and Taylor. That was a wonderful webinar. You provided some really great information to us. As for the questions, I do not see any questions at this time. However, if anyone does think of a question, please feel free to reach out to myself, Dan, or Taylor, and we will be sure to answer any questions. All right, if you could take a moment to review us on Google, we would really appreciate it. Our next webinar with Dan and Taylor is Getting Paid Faster with Liens, Bonds, and Contracts. That would be at 3 p.m. Eastern Standard Time on November 14th. So go ahead and register for free at sunraynotice.com/education. And that is all we have for you guys today. Thank you so much for everyone that attended. We hope to see you at our next webinar, and we hope you have a sunny day. Thanks so much. Have a good day.
Thanks, Jesse.